Definitions. In this article, advisor, it means a person who. So there's a person who can and will be advising you and or the advisor of another type of transaction. This is at the request of the issuer, a confirmer, or another advisor. So only a request. You're going to see this in a lot of your agreements, talking about requests and asks. If you ask about a request, someone can advise you on what it is that needs to be confirmed exactly for that request. They'll get that information from another advisor, someone who they notifies or request another advisor to notify the beneficiary. So you're going to see in a lot of your agreements, notify us, tell us, notify us any questions that you have. We'll request from another advisor to confirm for the beneficiary that a letter of credit has been issued, confirmed, or amended. That's what advisors could do per request. Y'all got any questions? How y'all feeling?
So that's what like the seller would do.
Basically. They're the only ones who can do everything that everybody really want to do. They just talk about requests. A request, I'll notify. I notify, then I notifies or have notified all parties due to requests, different requests. Persons, advisors gonna do that. Applicant. It means a person at whose request or for whose account a letter of credit is issued. Now, when we're dealing with our billing statements, especially from credit card companies, we're dealing with credit card accounts. So if we have a credit card account, then from that credit card account, we have been issued a letter of credit. That is was used for another person to request that it be amended, confirmed, or even issued to another person, like a beneficiary. For their bank, they'll have a letter of credit. The terms includes a person who requests an issuer to issue a letter of credit on behalf of another. If the person making the request undertakes or promises an obligation to reimburse the issuer, you have a promise to pay. You're going to see that in a lot of your agreements. Each person who promised to pay will become an applicant at the time that they undertake or request from another, that original seller, who actually is holding the account. How y'all feel? Any thoughts?
Yes, this is crazy.
So it ain't what we think, right? So I really can't wait so everybody can see this application to understand what's actually happening. Why? This is why you're getting your billing statement every month.
And it's so crazy because it says that the applicant is a person that gets the letter of credit. So we know that's not us.
Mm-mm. But because we have an account, we're going to get the letter, we're going to be issued it.
Mm-hmm.
To see what the person is requesting from us. Is amendments, supplements, changes, confirmation, was issued. That person wants that so that they can request from their bank who actually got the account to issue them other letters on behalf of another person who actually made the request, you and them. So they become the applicant. This is why I say you're not the customer. Or they said that in Article 4 when they talked about the bank collecting and depositing. They're the ones who's going to be, that bank is going to be the ones who's making the request with the credit union, trust company, whoever the case may be, who issued the letter of credit. You with me?
Mm-hmm.
Beneficiary. This means a person who, under the terms, not just one term, under the terms of a letter of credit, is entitled to have its complying presentation honored. You mentioned honored to me earlier, Aaron. Yes, whatever is presented, it shall be honored, but it has to comply with the terms of a letter of credit. That means that the person who is entitled to it, they are actually the ones who is entitled to the payment. They have to be the ones who's going to honor it for a beneficiary so that they can get reimbursement from the issuer. the term includes as well, so that you know that beneficiary is going to be more than one person. Beneficiary also includes a person to whom drawing rights have been transferred under a transferable letter of credit. So that letter of credit that you have from a beneficiary of the bank, it could be transferred right back to them for as long as the beneficiary comply with those same rules that you told me that you see on the back. It's not for you, it's for them. They're just letting you know what could happen. They'll be the ones, if it's transferred back to them, to transfer a letter of credit to their bank, the beneficiary's bank, the bank that they were speaking about in 4A. So beneficiary and beneficiary's bank. These are persons who under different terms is going to be entitled to deal with the letter of credit. It should be transferred. One is getting it due to drawing rights of another like you, and the other is getting a letter of credit because they're simply complying and honoring what was presented to them from their bank, the draft. Any questions?
I just want to kind of quickly recap what I'm feeling right here on the so essentially each month we're kind of getting an application all over again, and we're just kind of filling that application out and sending it back to I don't want to say beneficiary, not the beneficiary, well, one of the beneficiaries, so they can send it to their beneficiary bank to get that credit.
The difference with this application is that this application you don't have to fill out. You've already filled out an application. This is the application for them to fill out, a person who's going to actually be given the request after you ask. So this other transaction that's taking place, this is the application for them. They are going to be the applicant, the nominated person to comply with the presentation and seek other documentation that is actually needed or the amount that is actually needed. How y'all feel?
Okay.
So when they talk about presentation here, are they talking about giving the value of the letter of credit or actually delivering it to
Yeah,
the
actually,
issuer?
actually delivering it, actually, transferring it, showing it, and having it honored by each and every person it's presented to by complying with the terms of that letter of credit. What are they saying on there? Did you read the bill? What is it that they want? What are these provisions saying that hasn't happened? Because whatever provision hasn't happened, this is now giving you the opportunity to have good faith under Article 5 and enter into a transition provision where now you're able to allow for them to apply for other benefits using that exact same item under a different term.
So when we're returning this back to them, is it just for us to say, hey, we know, we're trying to point out the provisions that were missed that are on the back of that statement, on the back of that billing statement?
What did you say?
I say, when we get our monthly billing statement, are we looking at that back and saying, okay, cool, these are the provisions that weren't hit. This is what we're sending it back for, so that they can go ahead and see the provisions that were missing, fill in that blank, and then get the rest of the letters that are needed for that credit?
Right, because that is the terms of the actual account. That is other important information about the account that goes with any other message that they may have about the account as each person who deals with it add to.
Okay, so then when we get that initial analogy credit card member agreement, that's something that kind of overlooks all the transactions. But each month, when we're getting these new account statements, these are separate contracts on the back that we'll think of. So these are separate agreements between the parties that we also need to make sure they're reinforced,
Yes.
which do tie back to the big agreement. Okay.
Yep.
Okay.
Yep.
Cool.
How y'all feel? Y'all with him?
Very much so.
Confirmer. It means a nominated person who undertakes, who promises, who commits at the request or with the consent of the issuer to honor a presentation under a letter of credit that's issued by another. So one confirmer is someone who is the nominated person to undertake and promise to transfer this letter of credit to you. This confirmer is also the person at your request who will work with another person, another issuer based on your agreements or your consent for them to honor the presentation. It has a presentation because they did honor a presentation, but then you're going to have a presentation as well, but it's just seen as a letter of credit. That's something that's going to be issued by another, indicating and identifying and honoring the request of the confirmer, the nominated person. So this is why they want you to notify them. They're the ones who transfer the letter of credit. They'll be the ones to keep transferring it through assignment. Unless they can't, then that's when dishonor comes. This is why you have a letter of credit instead of a presentation. The bank will have a presentation because they're going to be the ones to honor after, we have come together a mutual agreement that we both promised to do something with this letter of credit, but there has been some sort of failure in the time. But that's okay, because at this time, we're going to do something different. So dishonor. Dishonor of a letter of credit means failure timely to honor. So if you got the letter of credit or you got the letter and it isn't quite representing credit yet, there has been some sort of failure. Failure at the time that another person honored it. Or dishonor of a letter of credit means to take an interim action, a within action, an internal action, such as acceptance of a draft that may be required by the letter of credit. So in order to process a letter of credit, it has to be accompanied by some sort of draft, the draft that was accepted. This happens by way of internal action. They will honor it at that time if ever there has been any failure to honor it. So if you get a letter of credit and an amount is not there, there is another letter of credit that can be issued and presented for honoring. It's by request. The nominated person who undertake and promise to transfer it is the one who's going to do it and confirm that this sort of letter of credit needs to be transferred based upon rights. Rights to use the document. How y'all feel? What's y'all thought?
Is this like for the acceptance of a payment order?
Basically, it's utilizing that document that has that draft attached to it. This is why it is considered to be the letter of credit. That letter of credit is required to be accepted along with any other internal actions that needs to be taken. They need that, but you have it. They had to transfer it to you, or the confirming or nominated person had to transfer it to you, because at that time, it couldn't be honored within. It has to go out first.
Right, because I remember in there it was talking about the acceptance of the payment order and how it can't occur before it's received by the receiving bank.
The person who's going to be accepting the draft that's actually attached to that statement that that other bank gave to you. That document. It's a record. It's a letter of credit. And under 5-10E is capable and have the power of being examined and used. People keep asking me what's next. What they got to do? You got everything. Get the document? A document means a draft or other demand, or a document entitled investment security, certificate, invoice, or other record, statement, or representation of fact, law, right, or opinion that determines two different things. So these documents are used for many different reasons to be presented as facts when it comes to law, rights, or someone else's opinion, what someone else believes. On the back of the bill, you're going to see them say, what do you believe? If you have rights to use this, say something. You have rights to choose the law, say something. If you know it's a fact that it's been misrepresented, say something. State that so I could put it on the record. And use your invoice and a certificate that is attached to it, because it's a security investment in a document title for another person. I can give a demand using it if you request. I'm gonna use the draft part to do it for two different reasons. One, which is presented in a written or other medium, whether it's online or actually mailed to you, that's permitted by the letter of credit, or unless it's prohibited by the letter of credit, by the standard practice referred to in section 1-508. So they're going to be presenting to you a written document. Come in any medium. If you want to write a fact to them, present the law to them, give your opinion to them, it can be done at any medium that is permitted by the letter of credit. They're going to tell you, call me, email me, go online. They're going to tell you. And a document is used and is able and is capable of being examined for compliance with the terms and conditions, both of them, of the letter of credit. A document may not be oral. You have to actually have it. You have to actually present it. They have to actually see it so that in good faith, they can deal with the facts and conduct the transaction in which it is concerned. They always tell you in your agreements why good faith and who it concerns. When they are presenting and having good faith to you, they can't orally express it. They're going to imply it by giving you a letter that meets terms and conditions, or at least one of them. And that same document that you have, that exact same document, is capable of being examined for compliance to make sure that it matches other terms and conditions. If those additional terms and conditions apply, then you're dealing with something according to standard practices that can be actually used in all of these other different ways. It's a good faith. That's the only thing that's going to honor a letter of credit. That's because of another transaction. Dealing with the facts and actually conducting that transaction. That means that they're relying on the individual to have good faith. It's going to take you back to Article 1, where that individual, the moment it comes to their attention, should be conducting another transaction. A transaction in which one that concerns the document, not a transaction in one that concerns your FRNs, because we didn't see none of that in here. But if that's the other medium that's permitted by that letter of credit and they'll take it, they will take it. How y'all feeling? Any questions? Any thoughts? Do y'all understand?
Yes, I'm tracking.
Okay. So honor of a letter of credit, it means performance of the issuer's promise, the issuer's commitment in the letter of credit to pay or deliver an item of value. Who promised to pay and deliver a valuable item?
Beneficiaries bank.
Issuer.
The issuer.
There you go.
The issuer also promised to perform. So they deliver your item that's valuable to them that they can use to pay. Unless the letter of credit otherwise provides, honor occurs in three circumstances. Honor occurs upon payment. You can do it immediately. Honor occurs if the letter of credit provides for acceptance. Upon acceptance of a draft, and at maturity, it's payment. So if it has a future date in which that draft can be accepted, then now you're dealing with something that provides honoring a letter of credit. Or if the letter of credit provides for incurring a deferred obligation, like that PennyMac section. Upon incurring the obligation at the maturity date, it's the performance. So on that date is the date that they will perform. The date that the letter of credit actually provides that they have the obligation to defer the payment and accept it at a future date versus trying to accept the early payment. Each and every document that you get provides honoring the payment, and is honoring in a way that an issuer can actually use that letter of credit to pay, remit, or use it to deliver an item of value to another type of issuer. This all happens when people use the obligations and their rights to utilize that document in whichever way provides to them at that time. You got to do it at or before the maturity date. So one bank honors it before the maturity date, and another bank will defer the obligation and honor it at that time or at the future time, the maturity date. So early payments and late payments. That's what two different types of issuers are promising to pay and deal with. Whoever deliver you an item of value is giving you an early payment. Whoever is delivering or whoever is crediting, using the letter of credit to pay, then they're delivering or they're paying or using that late payment. So this is why fees will never be yours. It always will be on the issuer. Whoever that may be. Apostrophe S. So here they're breaking down these issuers. Who could be considered an issuer? Issuer means a bank, a person who is engaged in business, or other person, organization, or natural person that issues a letter of credit. But it does not include an individual who makes an engagement for personal, family, or household purposes. You'll never be the issuer. It's never going to include you, even though you're going to have the letter of credit. You're just going to have the letter of credit due to another person. That's it. That other person is going to be the one to promise the contract with that document on your behalf, on your personal, family, or household purpose behalf. They're going to do it. They're going to do it using the letter of credit. How y'all feel? Any questions? Letter of credit are used for purposes. If it's used for your household, it's used for their business. If it's used for their family, then it's used for their families and all the members of their family. If it's used personally, then that means that it's used for family or household or business purposes from issuers dealing with its payment, not your payment, but its payment that's attached to that document. They got a draft on it. Dealing with two different types of issuers at one time. We need to connect them. Any questions?
So the issuer is actually sending us payment every single month. That's what they're sending us, that payment. And they want us to send it back so that they can have it before the maturity date. And then after that, it's going to go to another issuer who will take it after that payment due date or after that maturity date.
Because they'll actually have a contract now from two people who came together and agreed to accept a letters of credit.
But initially, it's a letter of credit. So like by the time we take it, they get a letter of credit technically from us, or we still don't deal with the letter of credit when we're returning it.
They're going to deal with the letter of credit. You're only going to have a letter of debt. Whenever you make sure that they do what they undertook to do, they promised to do, meet all of the provisions, then they have letters of credit. Your letter that you have in your possession plus other letters from the issuer.
Okay.
The one who is actually forming the contract for the individual's personal, family, or household purpose. Anybody but you. It doesn't include you.
Okay. So if they don't do their job, then they don't end up initially, then they don't have a letter of credit if they don't.
Exactly. They had a form of a letter of credit, but that came from somebody else. It wasn't never because they initiated a transaction with you for a letter of credit. They're giving you a letter telling you something wrong with it, and it's not constituting as a letter of credit just yet, but it could if it satisfies the requirements.
Got it.
Do we still have a notice of credits or notice of a letter of credit?
You got the notice. Yes, you do.
Still keeping a notice.
You got your bill. You got the notice. That's a notice of a letter of credit, a draft that was drawn up from another person. What you have at that time is a form of a letter of credit from another. You have the opportunity to use the exact same letter of credit for another transaction that will satisfy a request. A different one, a new transaction. How you feel?
And that person that we're returning this notice back to, do we need to kind of initiate and let them know that we're trying to perform a new transaction? Is it something that's implied based on other language or something like that? Just an idea.
Right, based on the warranty. The moment that you initiate or talk to or transact with them, it's already implied that you're transacting with them. So they're looking for all of those warranties that you're transacting with them in case of a financial institution. That means that you have a letter of credit, which is a financial instrument. You utilize and you create that from the payment, from the document. Making sure that that document satisfies all the requirements For as long as that document satisfies all of the requirements and it's in compliance, you have a letter of credit, which is a financial instrument. It can be used for commercial transactions or international trade. What they're advertising to you is something that should be used for international trade, but all of the requirements has not yet been met. That means each person has not yet did what they promised to do.
And some common things, and again, I'm just talking through my ideas from reading. One of the things is it didn't come to the right address, which is something we addressed last week, where it should have gone to a different address, which was shown on that billing statement, but it was inadvertently sent to us. That's one of the provisions that weren't met. Is that correct?
Right.
Okay. And then another could be it's supposed to be in U.S. funds or whatever it says on the back, or whether it says we deliver it and it's only 5 days on there and it's supposed to be 31. All those were the provisions that we need to make sure that we're letting them know have not been met.
Exactly. So with your next transaction, it'll be within 30 days instead of 25 days. This is how you complete your 30, 60, 90. This is for a whole nother transaction within 30 days because you request that the applicant of the account utilize a financial instrument with another financial institution. This is using the document, allowing for it to reveal its true self. To be honored. So a letter of credit. Oh, no, I'm with you.
No, I was just saying, okay. It might be a little fuzzy because I'm driving as well. So, but no.
Okay. I'm with you. A letter of credit. It means a definite undertaking that satisfies the requirements of Section 5-104 by an issuer to a beneficiary at the request, or so the issuer by an issuer to a beneficiary. So from and to, pay attention to the two. By an issuer to a beneficiary at the request for the account of an applicant or at the request for the account of an institution to itself or for its own account, honor a documentary presentation. This is by payment or delivery of an item for value. They will honor their very own document. This is just in the case of a financial institution. Now, it can be your own financial institution or it can be of itself. It can be of its own. Any bank that you deal with has a bank. You want to utilize their bank with that payment. They will deliver that item for value to their own financial institution, to its own account for deposit, just as long as it satisfies all of the requirements of the issuer, the original seller. How y'all feel? Any questions? What's your thoughts? They're describing these different letters of credit for two different situations.
I know we talked about they were talking about multiple issuers. So it's the bank's bank, but are they also talking about the reserve?
Yeah, yes. Also, all of them. All of the issuers. Look at the ORs. Let me separate some stuff so that you can see that. So a letter of credit. It means a definite undertaking that satisfies the requirements of Section 5104 by an issuer. So that issuer has the apostrophe S there. They have an issuer because it leaves the issuer up in the air. It leaves a issuer up in the air to satisfy its own requirements when it comes to dealing with that letter of credit. After that issuer has done that, it's going to a beneficiary. A beneficiary at the request or for the account, they're going to be the applicant. This is in the case of a financial institution. Now, this can be your own or it can be their own. That's the first point that they're making about an applicant who's receiving documents from an issuer to other beneficiaries at request. That's one. Now, after that, or it's another case. So in the case of a financial institution, to itself or for its own account. So this exact same document that may have been sent to an applicant or to a beneficiary is the exact same document that's going to be used for its own account, no matter if it's a deposit account or a credit account. That exact same letter of credit is used for whatever account it came from. In the case of a financial institution, let's say it's not US, just a regular financial institution in the state, the letter of credit is required and given to honor a documentary presentation by the payment itself or by delivering an item of value to another issuer, Aaron. All of those issuers you was talking about. Now we're speaking of another financial institution because it's going to be a financial institution of the person who actually has it in their possession. So let's say if you get your billing statement, you got your own bank, you got your own financial institution. You can choose to utilize it, transfer funds to pay the bill, or actually pay the bill from that account.
Right.
If they have it in their possession, they have a financial institution as well. And using that exact same document, they're able to use it for itself and for its own account. They use it in two different ways, by delivering payment and by delivering an item of value. Letters of credit. What's your thoughts? How you feel?
That cleared it up.
So it's a nominated person for this. A nominated person to utilize a letter of credit. A nominated person to send a payment and give delivery of value, an item of value. A nominated person means a person whom the issuer, one, designates or authorizes to pay, accept, negotiate, or otherwise give value under a letter of credit. You don't have to give value to it. They'll give value to it during their legal negotiations. This is one they choose to accept and pay due to them being authorized to. Two persons are going to be designated on that letter of credit, you and another. One person can pay, accept, negotiate, or otherwise give value to a letter of credit. And another person undertakes or promises by an agreement or custom of trade or something practiced to reimburse. I'm a nominated person who, by the agreement, promised to see to it that they're able to utilize that document according to their customary practices. Not just one practice, but more than one. One that allows for them to use that letter of credit and get reimbursement. Take that item for value. Take this letter of credit for value and negotiate it with somebody else, not me. This happens upon presentation to that other person in practice. You're not in practice, you don't have the customary skill, but you do have the agreement. And you did promise to see that those with the knowledge to do those things would do it. So that's why they list out payment networks, transaction.
Did we lose her?
Kamaya, I think we lost you. We can't hear you. Is anybody else still on, or is it just on my
I'm
end?
still on. I think
Oh.
Everybody's
I'm sure she'll come back though when she figures out what's going on.
All right, Aaron, take over.
I was about to say you do it.
I'm still trying to wrap my head around this stuff.
Me too. I'm like when she speak, it be making sense, and when I go back and look at it, I be having to look at it 50,000 times.
where y'all
Yeah,
get
definitely.
up at? Where's the issue?
What did you say, Shelby?
I was saying, what's the issue? What you guys not getting?
You know what the issue is for me, and it's not that I'm not getting stuff. I overthink it so much, and I feel like I need to know like every little detail about everything, and that's what just throws me off.
Girl, look,
'Cause I don't.
I just came back in. I don't know what happened. I only heard a little bit what you're saying before they kicked me out.
No, you was talking before you
Yeah,
kicked
you
you
was
out.
talking before you kicked you out.
Oh, okay, I thought y'all stopped me.
Oh yeah, no, we were just
Yeah,
talking, waiting for you.
you
Oh,
was in
okay.
mid sentence and just
Mhm.
cut
Dang,
off.
okay, so what's the last thing y'all heard?
Start reading the definition. You can pull your screen back up.
Oh man. I don't know why they stopped doing all that too. Can y'all see now?
Yeah, it's coming together.
So you just started reading, I believe, nominated person, if I'm not mistaken.
Yeah, we were talking about nominated person.
Dang, that's crazy because I got all the way down to presentation and presenter and record.
Oh yeah, now the screen didn't even move or anything like that.
Dang, that's crazy. Okay, so I'll just start from nominated person then. So a nominated person, that means that this is going to be more than one type of person has nominated. So a nominated person means a person whom the issuer, one, designates or authorizes to pay, accept, negotiate, or otherwise give value under a letter of credit. So it's two persons who's designated on your document. You designated on it, and another person is designated on it. One person is designated on it from the issuer to be the one who's actually going to be receiving the delivery of the actual item. The other nominated person is the one who's actually authorized to utilize the payment to pay, accept it, legally negotiate it, or otherwise give value to it. So they will give value to it. You don't have to unless you want to use your FRN. You authorizing someone else to pay.
Is that
And
person on a bill? My fault.
no,
As you were talking about the three people, a little trinity on a bill. As
yes,
you have me, you have the person who has said, make payable to, we'll say, American Express or card service, whatever. But you have that person that has that logo in the left-hand corner. Is that the issuer who said, hey, I'm going to pay as long as this is returned back to me?
exactly. That means that there was
Okay.
another nominated person who undertakes by the agreement to pay or to see to it that they pay, or by a custom or a practice. So they have the practice and the skill for this customary trade. This is where your international trade transaction comes into play. And this is what's done by agreement. This is where we're dealing with Visa, MasterCard, Amex, those who are government mandated. Those are the ones who promise and undertake to pay. And those are the ones who's going to be reimbursing the person who presented to them. It's not going to be you. It's going to be the other nominated person who is designated or authorized to negotiate it, accept it, pay it. It should never be you unless you just want to pay FRNs, but that means that it's not going to be negotiated. Just accept it in a way by one of the designated nominated persons.
And the same thing would go for mortgage companies, whatever. They're still going to use kind of some version of an ACH network or something like that. It might not be like the big three. It would be something like that. Okay.
Yeah, but it's for sure going to be an ACH. Authorized.
Okay. I did notice that even the mortgage says ACH on the back of it too as well.
Yep. Yep. So presentation means delivery of a document to an issuer or a nominated person for honoring it or giving value under a letter of credit to it. So the person who's going to be presenting it is the one who's giving value to it under the letter of credit. So whoever is the nominated person who issued it to you, that is the person who can give value to it under a letter of credit. And the issuer of the actual document is the one who's going to reimburse them. It has nothing really to do with you, but the presenter. You won't be the presenter. The presenter means a person who is making a presentation as is, like that issuer who delivered you the document, or a presenter is a person who is making a presentation on behalf of a beneficiary or other nominated person using a record. This means that they gave value to it, or you even consider honoring a letter of credit with the person who was nominated to transfer it. How y'all feel? What's your thoughts? Presentation and presenter. Presentation is what happened to the beneficiary's bank. If a presentation is happening to the beneficiary's bank, it's going to have to happen by the beneficiary or a nominated person of the beneficiary, like the issuer, the one who issued it to them. They're going to send it right back to them. They're going to be working on behalf of a beneficiary. If you want to be a beneficiary, then it's you. They work on behalf of a beneficiary or a nominated person. That second transaction utilizing letters of credit is due to the nominated person. The transaction using the first letter of credit is for a beneficiary. So it was presented to you, and you will be someone who can help another beneficiary make presentation as a presenter to another person by giving value under that letter of credit and honoring it for the issuer. The original issuer. The original issuer or seller, Aaron, is the one who practiced reimbursements or customs of trade. So if it's presented back, it's for international trade. That's a different transactions where they're using the same record along with other records. So this is why they have record defined again, although it is defined in Article 1, but there's another transaction that's going to involve another record for the presenter or for the nominated person so that they can actually get it back to their bank. Your one letter of credit isn't enough. And then here you go again, Aaron, successor of a beneficiary, coming in a minute. But we know what record is. It actually could come next. But how y'all feel?
So could the presenter also be the intermediary bank?
Yeah, it could be because they could become a nominated person. Just
Yeah,
like the
I
Payment
was-
Networks is nominated for Navy Federal to rely on information from them, they're nominated for that. They're the ones who's going to work on behalf of the beneficiary, which is Navy Federal. They're the ones who's going to communicate with Navy Federal's credit union. They're going to present the presentation to them
Yeah,
after they give value.
that's how I was looking at it.
And is that on the statement or the agreement or both that we're
It's
talking
on the
about?
statement. Yeah, it's on
Okay.
the statement.
That was
On the
the
back of it, where they give you information about the actual account and the delivery of the item that you received.
Excellent.
So record means information. Information. If you want to do anything more than give information, then they may not can't put it on record. Do y'all understand?
Yeah.
It's about information to a nominated person or a beneficiary who will work on behalf of the presentation. That means that they'll work with others, utilizing a letter of credit, giving value to that versus giving value to a debt note or something that's not yet a record, but just a statement. So a record means information. There's other very important information that's missing. Record means information that is inscribed on a tangible medium or information that is stored in an electronic medium or information in other mediums that is retrievable in its perceivable form. So you have a record that is retrievable, but just not in its perceivable form for the successor of the beneficiary. So they send it to you in a medium that is describing or inscribing information for another person, somebody who's going to use it a little further, someone who's going to be considered the successor of a beneficiary. This means a person who succeeds to substantially all of the rights of a beneficiary by operation of law. Choosing the law, including incorporation with or into which the beneficiary has merged, come together with, or consolidated, an administrator, an executor, and a personal representative, a trustee in bankruptcy, debtor in possession, a liquidator, and a receiver. You can consider yourself to be a receiver. But you shouldn't be that receiver for long because it should be in possession of a debtor. The exact same person who sends it to you. You're going to be the ones who's going to be liquidating that exact same item under bankruptcy laws. Because the debtor is the one who forgot to do something in the original filing. So you're going to see in a lot of your bills them talk about if you file for bankruptcy. Because there's someone else who actually under bankruptcy laws can execute that document and become the personal representative for whoever. Just as long as they come together. Just as long as all of the duties and the requirements and compliances is happening together with corporations, organizations, companies. It's all done by operation of law. If ever it get legal, then it may be something else going on. How y'all feel? Any questions about the successor of a beneficiary? They the ones who succeed in collecting everybody rights, all of the rights. They have all of the rights reserved.
That's the intermediary bank too, right? It's the payment networks.
Them too. They'll become the beneficiary. That's the one who's merged with other beneficiaries to consolidate these documents, to liquidate these accounts, to do all of the personal work that they can't technically do with another person because they don't have all of the rights to. They may have a right to do something, but not all of them. And the successor of the beneficiary, that's the one who have all of the rights.
Yeah, this also makes me think about like the credit counseling services and how you
That's the personal finance department.
can use them when you're in like a financial need. And I was reading, it said something about creating secure transactions to cover basically when you can't pay.
Yeah, items and documents. Cover other accounts. So everything is based on acceptance, or value whenever we transact with each other. That's the value that's being accepted at that time. That's why the value of the amount is left open. Giving somebody else a chance to transact in another way, to actually perform acceptance and accept the draft back. Become a receiver of something that they now can liquidate. Something that is put back in the possession of a debtor. Somebody who owned that UCC filing in that original first transaction. We just accepting our documents for value each and every time we get them, and allowing for another person to accept it and another person to accept it until everybody becomes successful in being covered. So each person got their own job to do. So they're going to receive a form, and everybody going to perceive that form in a different manner so that we come together and everybody's covered. So nobody technically pays. So this is why the interpretation that you have is applicable throughout Article 5. When you get your documents, how you believe or what you believe about it is up to the interpretations of Article 1. They don't really more so care about the opinion, but the construction and the principles when it comes to dealing with the documents, dealing with the agreements, dealing with the contracts and what it contains for this value or in order for it to be accepted.
So that's kind of like the implied warranty of a particular
transaction, particular custom, particular practice. It all is going to go back to Article 1. So from the moment, it doesn't matter if we sit in front of each other. I grab it, I give it to you, and you touch it. It keeps going back to Article 1 each time a new person touch it. How are you using it now? You touched it. What operations of law? What rights do you have to it once you have it? Substantially, how can someone else secede from it? So each and every time you place your hands on a document, whether it's now, later, in the future, whenever you place your hands on it, it's time for you to take action according to the interpretations of how to deal with the document interpretations of rules that it needs to go through buy sell trade. It's going to be accepted on a lot of different levels. So whatever it appear to be is going to change because of transactions. How y'all feel? Y'all with me? What's y'all thoughts about that? Y'all got any questions? How y'all feel? Aaron with the A, where you at?
I don't think he in here.
He was in the beginning. Some people probably getting kicked out. I know a lot of people was like on the go.
He's
I'm
only
still here. I'm still here.
Jared said he's still here.
I'm like, damn, was that
Yeah,
him?
sorry, I'm in the car, so I don't know how good the audio is, but no, as you're like reading through this and you're talking about it, I'm just picturing like every single time that we're getting this stuff, we're creating a new transaction. So that's why we got to keep going back to one, and that's what I was doing last week, just kind of going back to volume one or article one, to truly understand like kind of what is our role in these transactions? What do they really just need from us? It's so simple to give them our right. I think the biggest thing I'm missing is, and you said it many times, we need to give our rights so they can have rights. And it's trying to figure out like,
So even with that
what our right is.
question, like not to cut you off, but even with that question, you could ask them what else is needed. You see the agreement, you see the other provisions. Ask them what else is needed. Do y'all know what else is needed?
Yeah, and so I asked those questions.
What y'all need from me? Like what y'all need me to do?
Everything you have is right there. Every time they say that, they're just like,
like,
oh,
go read
it's
it.
there. I'm like, yeah. So I'm like, okay. They always say, hey, everything you have. As a matter of fact, I called just Mr. Cooper, which is something we deal with, from time to time. And, talking to the lady, I even started asking questions, trying to get a little more confident on the phone, ask certain questions. And she was like, no, everything that she did say something important. She goes, oh, did you include the late fee? Now, it's not late based on whatever bill statement I got. But she did say it because I asked her, I said, can I use this statement to help the next person make payment? And she was like, I don't know what you mean. I don't know what you mean. Then I kept just saying the same thing over, and then she was like, "Oh, well, you can use it. Just make sure you add the late payment on there," and that was it.
Right, because the late payment is to the future. It's not a late charge or late fee. It's just a late payment. She gave you early payment. Anytime you get your billing statement, you get an early payment because it's due at a maturity date or by a maturity date. So that means what we have to do is make sure that payment is actually being made and fully, all of the requirements to operate it by law is fully there.
And the laws that we're under are going to be UCC laws, but they're abiding by the same ones.
The state is, yeah.
Okay, so I'm in Florida, so even if this agreement comes from, whatever state it comes from, I just need to make sure I'm abiding by, Florida UCC laws because they practice do business in our state. And what I'm trying to activate is just the federal law so that they can get that dollar for dollar transaction from the government.
Right. So wherever you're situated, wherever each person is situated, it's fine that they follow the laws of where they actually situated. So even though, let's say if you are in Florida or it's going to Florida and you in Virginia or whatever the case may be, whatever UCC state laws is still going to apply. It's just at that person at that time where they at. So if you're in New Orleans and you don't got Article 2, then Article 2 ain't applying to you. When you get it back to whoever is going to, Article 2A immediately will apply.
When I get it back in Florida, since we have our whatever state they're in, they have Article whatever it may too, they're gonna take that as a contract for sale now.
Exactly. And those are the codes that they will follow under Article 2. Those are the things that they will be citing so that they get insight on how to push things further along. That's how they're gonna gain.
Gotcha. And so how are we held liable as individuals in a transaction? If someone says, okay, well, yeah, you sent it back. Yes, you expressed that there were terms missing and you pointed them out and still there was no credit. Are we doing everything that we need to do on our end in order for them to do what they need on their end? Or you feel that, no, there's still something you're missing as the individual that they just say pick up?
It depends on what you did with that document.
Okay.
and all the things that can actually happen in that document, which is one and two things. That document is considered to be a draft, a demand, a document entitled investment security, a certificate, an invoice, a other record, a statement, a representation of a fact, a law, a right, opinion. How you and what you talking about as you talking about it or talking about that document, it just truly depends. Now, what document you talk about is the one that was presented and that was already written. That document that was already written is used for all of these different things. So the reason why a lot of the times they're confused because they don't know which way you want to use the statement. If you say statement, then you right here. Conspicuously, they talking about a record because that record can be any of these statements, whether it's your opinion, whether it's your rights, whether it's the law. The way they present that written document to you and how you can use it is based on other permitted use using it. What's prohibited is stopping it from being used by its nature of the letter of credit. Standard practices is stopping it. So as an individual, whenever it is actually presented to you, you make sure that that document is used in other mediums. They need to seek instructions on that. It's based on your opinion about it. It's based on what you believe about it. It's based on your rights that you know you have when you get it. It's based on the law that you are choosing at that time. It's based on the representation of a fact. You got the fact the one way, but how is it represented? By you now. It's capable of being examined for other things. It's capable for being examined for compliance with terms and conditions. So that's something
if I feel I got a check, if I feel that if I got a draft, I'm letting them know that I received the draft because that's how I perceive it as being a draft.
Exactly. And then for them, they have other demands or other, things that they can list it on. So now they're going to be talking about, and now they're recording everything for the record. What statement are you making after you say you got this draft? Are you trying to make sure it's presenting all the facts? Are you trying to make sure it's used correctly? Are you trying to make sure that the opinion of it is right? Are you trying to make sure the belief of system of it is according to all of the standards? What do you want? What are you referring to as? Do you want me to examine it? Do you want me to inspect it? Now that you got it.
Okay.
What?
What do you believe? And then ask questions.
Right. That good faith is in Article 1 and 2. Your document can't be oral. Like, they're not going to get you. It can't be. It has to be information described on a document.
Glad you went back. This definitely went over my head when you first went over it. I don't think I had one question about it.
Dang, what you was thinking? I'm gonna go to something too. What were you thinking?
I don't know what I was thinking. I think I was just trying to process it still, but that breakdown you just did was really helpful. What do you think about the document? What do you believe about the document? Do you want to make sure all the provisions are being met? What do I want them to do?
Right, and that's all I keep saying. People want me to tell them I'm doing magic, and I'm not. What the fuck more do y'all want? What more do you want? You want me to do some shit that ain't in the capacity to be done? I can't. You just see these additional terms and conditions that could apply or may apply. I can express that. I could talk about that. I could message about that.
Yeah, and I know you, when we were in school, you kept bringing up the exceptions, and that was a big thing for me because I'm like, all right, yeah, she's talking about that, but just to really see it, those additional terms that could apply, or the exclusions that also could apply, that was a big thing too.
Based on if it's permitted. What medium, what way are you using it? Only you can determine it. What do you got? People be wanting to name it. They want to call it all of this stuff. What about just the document? What about just the item? What about just calling again and asking questions about it? People think that that's not enough, even though they just said here that they'll do everything else in good faith if you just concerned about a transaction. You're an individual concerned about a transaction and you actually want to conduct the transaction you're concerned about, then they'll honor it. They'll perform. The issuer is undertaken to pay, deliver, negotiate, do all of that. Not what everybody want to do. It's I can't say it no other way.
Yeah.
And then
limit the possibilities of it when you put a name on it.
Right. Other people talking when we was in school, like, yeah, I called it a payment. Well, okay. Like, okay. You call it a statement, okay. There's ways that they're gonna deal with a statement. You call it a payment, okay. It's ways that they're gonna deal with a payment. So that means your knowledge and understand that a payment is dealt as a financial instrument should have been in your mind. And that's something you should have been saying next. Or that's something you should have been looking forward to hearing after saying a word like payment. If not, then she got the wrong type of payment idea. So that's stuff that you gotta know. Nobody can tell you what that person gonna say. This is why the information is important to know. Who honors what? When does honor actually occurs? It occurs in three different situations. 3 different people gonna be honoring the exact same letter of credit. You started it. You used the plastic card, or you applied for the plastic card. That was the first start of a letter. And then now you done use this plastic card to get another letter. Now it's another person who can use that exact same letter by the maturity date. It's based upon if you defer that goddamn payment or not. It's that whole section of Penny Mac we was talking about. Deferring that. Can y'all still see my screen?
Yeah.
Yeah, okay. Somebody was calling me, that's why. But I don't know. It's like they putting it there to give you the warranties. That's one of the first things that, or I mean, I did mention it, but this the first things that they say right here before they get to remedies. It's warranties. They warranted some things. The other things, the other warranties, you have to express based on your rights to do that. And your rights to do that gives them the remedy to go on without unauthorized use. How you feel? Formal requirements is something that they spoke about too in Article 2. Formal requirements of a sale is the formal requirements of a letter of credit in good faith. Do y'all understand? Did y'all put that connection together from here? This Article 2 where they speak about form, formation, and adjustment of a contract.
Like form all requirements.
Yeah, that's so sweet. Like in general, it's some requirements of the letter of credit. Like it's the formal one. It's a formal requirement. Or it's a form required, then there's another form required. It's S at the end of that. But yeah, that's so sweet that they did that. A letter of credit. Confirmation. Advice. Advice. People just won't give advice. I believe this. I think this. Let me give you advice about this. Or seek advice about it. And listen to it. Transfer. Amendment. Or cancellation. May and could be issued in any form that is a record. In any form that is a record and is authenticated. You can't authenticate a record, but you have a form that can be authenticated and considered to be a record. That means that they have performed some sort of cancellation and amended the previous form and transferred it and got advice on how to actually do that. That's what allows them to have confirmation of funds using a or the letter of credit. A letter of credit, confirmation, advice, transfer, amendment, or cancellation may be issued in any form that is a record and is authenticated by a signature, or it is a record and authenticated by or in accordance with the agreement of the parties. That's why she said you got everything you need. Don't you got the agreement? See what was agreed to. And see that the parties of that actual agreement act in accordance with it. Whoever promised and undertake the prayer, especially in Navy Federal, is an authorized user and a card user. You need to see to it that the card user and the authorized user come together to use this one form and authenticate it. The signature should be there. And then the other person will act in accordance with the practices of the agreement. Somebody need to act in accordance with the agreement of the parties, or the standard practices that is referred to in section 5108E. So 5018, this is the second time mentioning it. The section in this article, or this section of this article, refers to standard practices, or it refers to the parties acting in accordance with the agreement. So it's very important. They're going to be hitting on a lot of different points there when it comes to signing this record, acting in accordance with authenticating this record, canceling this record, amending this record, transferring this record, giving advice about it, confirming it, having a letter of credit. Two formal requirements. One, has to be signed. Two, it has to be signed with the accordance of the agreement. If in the agreement it don't say that you, Aaron, signed, then you, Aaron, shouldn't feel like a party of the agreement to actually have to sign. But you do know that there is a signature that needs to be there to authenticate the statement, just in case. So it becomes a different form. If you want to, though, it's in a case, an appropriate case, or just in case you want to. You want to act just according to the law and practice this. Consideration is not needed for that. You choose what you want to do. When I got the document, I consider what I want to do and I'll benefit from it. Vice versa. Consideration is not required to issue a document, amend a document, cancel a letter of credit, cancel an advice or a confirmation. Consideration is not required. It's an element of a contract, but it's not required. Might get the offer. Somebody may accept the offer, but consideration for the offer or another offer may not be given. How y'all feel? What's your thoughts?
I was thinking consideration more in the terms of like kind of how diligence was.
Yeah, you can definitely think about that too. That it may not be given, even though it's not required to issue it. But yeah, you definitely could look at it that way because we are conducting transactions. So they don't have to consider due diligence. If they don't consider due diligence, they don't have to consider signing it for the amount or transferring it to the proper person or using it as a letter of credit or none of that. Not until you come along. Not until you get it in your possession and you want to know what's required to use the document in accordance of a letter of credit. Then that's when they can give you advice. That's when they can confirm the value of the item. Because you consider using the document, not actually using it. They'll use it. What's your thoughts? How you feel?
So the individual is the only one who has to really have consideration.
Yeah, really? Because we're the only one who was alive who couldn't express any agreement in terms. They can only imply it. So, if we want to consider another person or enter into agreement with another person, we're going to establish a combination, making a contract. And that's going to be by considering the documents that are in our possession whenever they are in our possession and not considering anything else but the facts and the law surrounding that at the time and the statements that we make about it, the questions, the advice that we seek about it, the clarity, confirmation that we get about it.
So that's a key question, Kamaya, to ask him. I want to consider using the document as a letter of credit.
Yeah, you could definitely do that. And they'll let you know, well, it wasn't considered at that time because they didn't know.
Right.
They didn't know what you was going to use. It just wasn't considered then. But now at this time, if it's something that you can consider, then I may consider it as well.
To move it along.
To move it along.
But so can we imply that consideration is
You
needed?
express everything.
Because like in here, I don't see like where it says anything about payment. So I would think that
No.
consideration is needed to make payment or to have payment made on my behalf.
And it's right. And it's needed by them. They need that to do that for you. They need that payment. That payment is a financial instrument that's used with financial institutions. They need it back. How y'all feel? Some things they didn't consider. We know that from the exceptions and the differences. They didn't consider it all. They considered some of it based on their limitations to deal with the document at that time. That's it. That's where the mistake comes in at. That's when the potential error comes in at. What they could have done at the time or what they couldn't have done at that time, but now they can now that you got it at a different time. So many things has changed from day to day. So surely, whatever was issued, they can amend, cancel, and change during that time. If they have to. They have to have reasons to. That means that they had to consider something else. Considering factors. CFPB.gov. Federal law. They didn't consider federal law. Why would I? The state got limitations on me. That's what I'm considering. My obligation is to the state. Who your obligation to? Determine it at the time you got it. And whatever was determined, cancellation can be informed or it can be amended by the person who issued it to you, the issuer. So that means that someone who's nominated to deal with the issuer and all of that good stuff has to be the one to present it to them. If you send it to them, they're going to send you a letter back saying that it wasn't accompanying no funds. It wasn't accompanying enough documents. You may not even look at accompanying to even think that that word mean that. It wasn't enough. How y'all feel? It's a lot. Y'all just like, y'all get it, but this article is something to really know. And you know, just to get in your mind, that way you see your bill a little different. That way when you see word like letter in your letter, that there's another letter that need to go with it so that they have letters of credit. And each letter they will purchase, each letter will be received, and each letter that is received go towards forming this considering contract.
Yeah, it definitely makes sense.
They sent you 1 through 6, 1 through 7, however many pages that they sent. You're going to just take one from that. There's more that they could consider to go with it, but they just haven't considered more to go with it yet. There's no consideration for that one by anyone using any form to consider for it or that type of transaction. So issuance, amendment, cancellation, and duration. Different times, cancellation, payment times, all that stuff. Y'all going to be seeing that in a lot of your agreements. Y'all going to have payment schedules for a certain amount of days. Each one of those payments can be canceled and amended. Terms can be supplemented. Additional terms and conditions could apply. A letter of credit is issued and it becomes enforceable according to its terms against the issuer. When the issuer sends, so 1, the issuer sent you a letter of credit with a term. The issuer is the same person who you're going to use that exact same document with for the other term. Or the issuer otherwise transmits it to the person requested to advise or to the beneficiary. We want the issuer and the beneficiary to work together. The issuer is going to be the one who's going to transfer that letter of credit to the issuer so that they can set the other term. Or they're going to be the one to set it before they get it to the issuer. You don't have to. A letter of credit is revocable only if it so provides. Otherwise, it's irrevocable. Got an option. If you give it back to them, they have no option. They have to use that letter for credit because that's what it provides for. Now, when you have it, it may provide for debt notes if that's what you want to give. But when it comes to them, it provides that they complete the terms so that it can become enforceable according to the terms of the agreement. Because right now, or whenever you get it, it's not. So it has to be in compliance. What you get provides for that because it's not in compliance already. It's unenforceable and invalid due to statutes of limitations in the state. Y'all got any questions? How y'all feel? Y'all see?
Yeah, I see. It just brought me back to what you and Jared was just talking about the document.
It provides so much information. And all of the information, when the issuer sent it, wasn't there, it wasn't complete. So the issuer has the opportunity to conduct another transaction that's different than that one, that allows for them to transmit it for the beneficiary. That means that they'll accept it for the beneficiary, but only if it's requested. After a letter of credit is issued, rights and obligations of a beneficiary. They're not putting the title on the beneficiary. They just said after a letter of credit is issued, rights and obligations of a beneficiary, of a applicant, of a confirmer, and of a issuer are not affected by an amendment or a cancellation to which that person has consented, to which that person has agreed. They're not going to be affected in a bad way. It's going to become effective in a good way for the issuer, for the person who confirmed the document, for the applicant, the one who presented it, and the beneficiary who has the obligation and the rights to actually use it with their own bank as a form of a letter of credit. It's to the extent that the letter of credit provides that it is revocable, or that the issuer may and can and could amend or cancel a letter of credit without that consent. Without your consent, without, they're going to say in your agreement, permission, the issuer is not able to cancel or amend that document. It provides to the extent that if they want to have a letter of credit, they must give it to the person who can actually see to it that action to cancel or amend the document could actually take into effect. So all of the documents that you have don't have no effect on them whatsoever until you come along and agree to actually allow for them to accept the document for a new transaction or add to it based on other terms and conditions. Or really, let's just say terms. You're not conditioned unless you just think you got to pay FIN. So everything that you are operating from, or whatever individual standpoint you coming from, is to make sure that the document that you're dealing with is enforceable according to its term. Whatever its term is, they're going to see. They will be advised of that as they request the instructions of what its terms actually is. And once they forget it, then it will provide for them to have a letter of credit based on the rights to have it. All because you considered it being effective for someone else. It's not until you agree that that can happen. How you feel? Any questions?
So are the other parties not affected because like it's technically perfected as it moves?
Yeah, because they did it. Remember in the first transaction. That's why they keep referring you back to Article 1, because yeah, it's already done. They did it, yep. So if you want something else to be done, then from that point forward, the amendment that they're gonna make is a UCC 3, where now they're making changes and amending the actual first filing. This is where the statutory lien comes into play. For the other person who is issued a letter of credit under rights and obligations to use it, either as a beneficiary, an applicant, a confirmer of the document, or the issuer of the document. They'll be the ones to utilize the document and continue to utilizing it further. It provides that they use it, not you. So from time to time, they're going to use it according to how they can actually use it from time to time, depending on when it becomes enforceable according to terms, not conditions. If you have another term, then the condition going to apply because according to this term, we now got to do it like this.
And that's after the
After.
yeah. It's after.
So it ain't going to happen no time before, just after. If there is no stated expiration date, if you don't have an expiration date, or other provisions that determine its duration. So if you have a document that states the expiration date, or if you have a document that do state the expiration date due to the provisions, a letter of credit expires 1 year after its stated date of issuance, because they do things yearly, 12 months. If none is stated for the 12 months, it's after the date on which it is actually issued. They're gonna tell you 6 consecutive months, hoping that you come together to merge it, and they have for the whole 12 months, the whole 1 year, letters of credit that was used from time to time, determining the provisions, determining the terms when none is stated. So whenever you don't see a term for the amount due, then it's your opportunity to go ahead and utilize that document due to another provision at that time, utilizing it so that you using it monthly to help match their yearly. Monthly and yearly, 2 different times we're using the exact same document for. That's what I said in my last session. If you can't get with the process month to month, then maybe you just need to file at one time 12 receipts in the beginning of the year when you file everything else. Yearly or monthly, you pick. A letter of credit that states that it is perpetual expires 5 years after its stated date of issuance, or if none is stated after the date on which it is issued. They're going to be utilizing these documents up to 5 years. You sign an agreement for 3, it's going to go 5, 6, and 7. But between that 5, 6, and 7 year, they may have switched your lender. They may have assigned it to somebody else. They may have issued it after certain provisions wasn't met, or they may have determined that at this time, since it's been past the year, I want to assign this duty or rights to somebody else. They could do that. Y'all see it happen with mortgages all the time. And with credit cards, they may decide what payment networks they want to work with, and some of them they may not want to work with. They get the opportunity to choose that. And they can change that after 1 year.
Is this why like closed or charged off accounts can still operate?
Exactly. So they're going to keep sending you those statements. Keep sending you those statements. Because in that case, your account closed. There ain't no expiration date. It's just other provisions that need to be determined still. So I'm going to keep sending it to you. Now, after 1 year of trying to collect, then I might take other type of action. But in the States, I got 5 years. That collector might hold on to whatever. Any type of course come for 5 whole years. And you wondering, where the hell this come from out the blue? They have options to utilize it.
So then does it so let's say it is a charged off account and it gets sold. Does that 5 years then start over because it's technically like a new account?
It is a new account, and something new was added to it. So let's say, for instance, last 4 digits of your account number is like 2455. When you come to their account, because they added additional terms and conditions, it may be 24551.
Mm-hmm.
That's that one little thing, just like our one little word, or just like this time versus that time, make a difference in what is actually being dealt with. Even if they put a letter, it's a different type of account. It's something different that's stated, and it happened after the fact. So it changes its formation in general. But a confirmer, a nominated person, or advisor should be the one that's helping directly with what's obligated to be changed or who has rights and things like that. It's not really technically us. This is why we request, we ask, and they notify. Notify that we're considering something else. Somebody will be a confirmer that actually can happen. And then somebody's going to be the nominated person to see to it happen. And somebody else going to advise the other person of what's actually happening. Everybody got different jobs. If they didn't, they would have found a way to make all of these persons one. Everybody different. It's a confirmer of it. It's a nominated person to use it. And then there's somebody who is advising them on how to do that. That's different departments. These are transition provisions for different persons who's working together, helping each and every person work be light, not taking on too much, but just light work. And for as long as we all come together, then we can deal. It can be handled, be shipped. How you feel?
They doing the most.
Okay, trying to include everybody. That's why I said that uniform stuff is crazy.
Mm-hmm. But I get it. It's a chain of command. So
Or order. So a confirmer. A confirmer is directly obligated on a letter of credit. And a confirmer has the rights and obligations of an issuer to the extent of its confirmation, not to the extent that they is the issuer, but a confirmer when it comes to a letter of credit do have certain rights and obligations to the extent where they can actually confirm that the letter of credit is meeting its obligation. They'll know, a confirmer. I'm somebody who I would consider myself to be a direct confirmer. Because each and every time I receive my letter of credit, I'm using my rights to determine that there's some obligations of an issuer that just has not been done or confirmed yet. I need them to confirm what's next. What's wrong with that? If I'm considering using it, just get the instructions to. Once they get it, they'll follow it. Because the confirmer, not conspicuously now, also has rights against the obligations to the issuer as if the issuer were an applicant. Now we're sharing titles. And the confirmer had issued the letter of credit at the request or for the account of the issuer. So each and every time an applicant, or let's just say an issuer, is dealing with another person, they're dealing with someone who is confirming an application of another. And then they'll work for that issuer who issued them the account, who issued them those letters of credit. They're working on behalf of that person. So you will see that, especially Aaron, you coming to LA, as you gather these documents, these are necessary documents that they're requesting for the issuer of the account. The issuer of the account need these documents so that all obligations can be met. Your document is just page 1 of that. It's the first thing that's starting off this new transaction. So this more so reason as to why you can't sign, because you're not going to be there to sign each and every page. So you don't necessarily have to worry about signing that page, but just make sure that it's included with other letters so that an applicant or a confirmer can deal with the nominated person. Confirmer, an applicant, issuer, an applicant, titles, they're going to change depending on who's dealing with the document, who's obligated directly to it at that time, and what's actually going on. These titles and roles are going to change. So first there's a confirmer, and then there's going to be a nominated person. And it's not going to be the confirmer, because it's not going to be them. It's just going to be a nominated person who may have worked with a confirmer at once upon a time who was dealing with the applicant. Somebody who issued them documentation with important information.
So then the applicant is the issuer?
So yeah, they will be, because this issuer is the exact same applicant who's going to be utilizing this document in another way. We're returning it back to the issuer. And that issuer is going to be using it in another way. So that means that they're applying it according to different terms. They confirmed that it was something else that they could do for the account versus taking your money. So the issuer switches its role to apply for 2 different things based on rights and obligations that the issuer will have. The issuer is going to work with applicants, confirmers, meaning that we both agree in this application that this is what's going to happen. A person who agrees to present that afterwards through assignment. Everybody got a different job. How you feel?
I see where it's going to switch at, because I was thinking like the issuer is the applicant. Then like if we're talking Navy Federal, they would be the confirmer, but then the payment network would be the nominated person.
Exactly, as the issuer, the person who's actually using your remittances. So the switch that you're going to see happening and coming is the switch from a commercial transaction to an international trade transaction. Due to a request for the account or a request for the letter of credit in a different way. The issuer gonna act as if they was the applicant for this international trade transaction, even though they was the issuer in a commercial transaction of a letter. Hoping and requesting that you ask or allow for them to notify the seller of another way to use the account versus using the account against you. You use your rights to use the account based on the issuer and what they're obligated to do. Not what you obligated to do. What is the issuer obligated to do? Pay, negotiate, transfer, transmit, do a lot of things by request that you just can't do, although you was an applicant at some point in time.
But so then does the payment network become the confirmer in like the international transaction?
So they will become the confirmer. And I won't say, the only reason why I won't say international is because they're just remitting it. That means that they're processing the remittance transfer. Once they process the remittance transfer, the U.S. financial institution gonna then become the confirmer of it because they gonna authenticate the record. So it's gonna switch again. Because now that they got it in their hand, that confirmer title can switch over to them, but only for a minute. Because the moment that they authenticate their record, now they're considered to be someone else, a different title. Someone who was nominated, someone who received something that was for value, or someone who was actually presented something for value. It's due to a person's request, a natural person or organization, an individual creating a contract for personal, family, or household purposes through another. So a lot of people is nominated on other person's behalf to do things. And there's one person who confirming that, yeah, I do want you to do this on my behalf. And then now it's another confirmer who said, yeah, this person did say they want me to do this. So now I'm confirming I need this to do this with. And then there's going to be another person who confirmed like, okay, yeah, I see all of these letters come together. So these person did agree to do this. I'll be the nominated person to go ahead and, issue this or transfer this back through them this way. I'll present it. I'll honor it otherwise versus the way it was prior to. Because now that way has been canceled due to amendments of the payment. Now it's a financial instrument for something completely different. Only because the confirmer also has rights against the obligations as the issuer. So a confirmer could be an issuer, issuer could be a confirmer. A confirmer and the issuer could both be applicants doing two different types of transactions using the same document. How y'all feeling?
The role switching be the only thing really throwing me off.
It's about to start switching to this. They're talking to you about this commercial transaction, but it's about to start switching as the letter of credit is actually amended, used, confirmed. Now it's confirmed by its nature to be used another way, according to a customary practice. But it only can happen at the request of the issuer. Same person who issued you the draft is the same person who is going to be using the payment network to issue and transmit this document in another way, according to rights now. Because of rights, they get different obligations to use the exact same document, so they'll confirm that for that reason. They're confirming that a nominated person, like you mentioned, can use it. The payment networks. A nominated person who is not a confirmer is not obligated to honor or otherwise give value for a presentation. This happens at the request or at a request. A person requested to advise may decline to act as an advisor. An advisor that is not a confirmer is not obligated to honor or give value for a presentation. So if the confirmer does not have the obligation due to the rights, then they don't have to present it to anybody else for value. So when you got it, you didn't get your item necessarily for value because the amount of it was missing. They didn't have to. They wasn't advised to. No consideration to do so. No type of request. An advisor undertakes, they promise, to the issuer and to the beneficiary accurately to advise the terms of the letter of credit. Can you advise the terms of the letter of credit? Only an advisor can, who promised to work with the issuer. Who promised to work with y'all issuers are the ones who's going to be seeking accurate information so that they can be advised of the terms of the letter of credit. So whatever amount that needs to be there, they're going to go ahead and seek the accurate information that they need to fulfill that term before they just take it upon themselves to actually do it. So an advisor promises to an issuer and a beneficiary accurately to advise the terms to either the beneficiary or the issuer of the letter of credit to confirm, amend, or advise or give advice that is received by that person, and undertakes to the beneficiary to check the apparent authenticity of the request to advise. It's going to be apparent, just like they let you know in Article 2. It's going to be apparent on the face automatically. That is the spot that is used to authenticate the record. It's going to be something that is requested and that is instructions and terms that the advisor will get from the beneficiary. Once they get that from the beneficiary, then the beneficiary will use a check to deal with the beneficiary's bank. It's because apparently on the face of that record, they now have an amount due to a request. But even if the advice is incorrect and they don't have that amount there, the letter of credit, confirmation, or amendment is enforceable as issued. So even though that amount is not there, it's still enforceable against you just as it's issued. However, it's incorrect, or the incorrect advice or the incorrect information has been given, because apparently on the face of his document, the record has yet to be authenticated. That is not happening until someone seeks advice from another person due to a request. Once they get that request, once they get advised on the terms, then they'll sign it and complete it. So they always ask you to notify us. I want you to notify them so that they can make it enforceable. If they are not notified, just like when Navy Federal, is invalid and it's unenforceable. A person who notifies a transferee beneficiary of the terms of a letter of credit, a confirmation, amendment, or advice has the rights and obligations of an advisor. It doesn't make them an advisor. They just have the rights of an advisor because the advisor came to them seeking out information on how they could complete the term. So they share a position for a minute. The terms and the notice, you already got the notice. The terms and the notice, which is going to be apparent on the face that a term is missing. The terms and the notice to the transferee beneficiary, it may differ from the terms in any notice to the transferor beneficiary to the extent permitted by the letter of credit. So by the time you utilize the notice and you add the term is going to be different from what they already previously transferred. It's going to be different. They're going to be using that document. They're going to be using that notice now based on permitted law, or based on ways that's just permitted by a letter of credit, confirmation, amendment, or any advice that is received by the person who so notifies. So any person who seeks out these instructions, any person who seeks out this advice on the rights and obligations that they have to use that document according to the terms, or any notice according to its terms for the beneficiary, they will get. The person who get those instructions, the person who get that term, the person who fulfilled that term will have to amend your payment so that it is enforceable and is able to be used and issued and received by their bank. Anytime before, it can't happen. It can only happen after they get a request to even place the amount, or after they have received from a person who was notifying them the amount. How y'all feel? Any questions, any thoughts? Which I think in 5-108 is going to get real good, real particular, because they're talking about the issuer's rights and the issuer's obligations to step into all of these different positions, to wear all of these different hats in order for them to authenticate a record, apparently where it has not yet been authenticated. And then someone else will certify it. And then now they have an item for value. What's your thoughts? How y'all feel?
I like
Hey,
the
Kamai,
part that stood
just-
out the most is the part about. Go ahead.
No, it was all subject, but as you know, to lessen my anxiety, Kamai, I don't want to lose you. You on 16%.
Mhm.
Yeah, on your charge.
Okay. Okay. Thank you.
But not another last week.
Listen,
Right.
let me tell y'all. Or how about another yesterday? Right there in the middle of the line. My phone never charged because I don't know what I be doing, y'all. I don't know.
You be zoned
But-
out.
Yeah, right. I don't even be paying attention. It's like half of the time I got my phone, and then it's like half of the time I don't get my phone. It's just weird. But okay, I'm going to the charge. I just be sitting outside sometimes too with something good out there.
Yeah, get that vitamin D.
Okay, so how y'all feeling? Y'all feeling a little twisted and tangled up since they switching their hats and one person can be three?
Oh yeah, definitely. But I do like the part about the advisor and how the advisor is there to make sure that what's supposed to be there is there, and we just need to make sure we make that request. We need to get, I forgot what exact word they use, but essentially
They're
asking for
advised on how
advice.
to act.
Yeah.
So they just need to be advised on, they need to act according to permitted law, or they advised to act according to state law. This is where they get different permission. Based on the issuer's right. We know any issuer that dealing with our document, they federally licensed. I mean, they got federal rights and federal obligations. That they can work.
So they just choose to operate by state law.
Yeah, because that's just what applicable when it comes to us having the ability to give up the security interest, give up the equity, and still have a part in it. Because the UCC is what the codes that they'll implement, and it's just gap filling that. Like, yeah, I know I gave it all up to you once, but let's do it again. So just because what I gave up or what I received, I don't technically got to pay for it, and you don't either. So we use the UCC, or they will use the UCC to fill a gap when they know that federal law should apply. But because I'm dealing with the individual under the state, it's just not right now. But I am able to directly be advised to deal according to this specific laws. How you feel?
So what gets them to act outside of the state? Like, what's elevating them? Like, once we return it, what's elevating them from this state statute of the UCC to some new federal with enacting it?
Consideration, considering it, considering permitted laws, considering other terms. If you consider other terms, then they'll consider the issuer's other rights and obligations that they may have to your document. That document to them could be considered a statement, notice, affirmation, advice, confirmation, so many things. So this is why a document. How can that issuer utilize a document? It's according to different rights and obligations as they deal with letters of credit. Meaning that you once had it, but you gave it to me. I was credited. Somebody else had a document, but they gave it to me too. And it come along with yours. So I was credited with all of these documents. How can the issuer use all of the documents? That's how they'll be advised. And that's how it shall be honored. No other way. What you thinking? Like, let's say, for example, for right here. Just in this one section that they upgraded in their agreement, that's not even an updated one. It's not in the old one, it's in the new one. This is the new one. But this is they updated in the transaction categories right before, oh no, this is the old one. Damn, I'll keep pulling up the same one.
Are you okay?
Mm-hmm.
Are you out?
Am I out?
Yeah.
No.
Can I talk to the meeting?
Can you talk? What you want to say to my meeting?
I love you.
Oh,
Oh, she heard
We
you.
love you too, buddy.
adorable. We love you too.
See, they heard you.
Oh, sweet.
Thank you. So you see in this transaction categories, they say you agree that we may together, you and I, rely on information provided by payment networks. So there's networks that utilize that payment. We're all relying on those networks to categorize transactions that's described below. These are the same networks and payments that, they're talking about here with these different rights and obligations that they deal with the issuer. They don't have or they don't know anything about anything or a new or another transaction until they're actually instructed, until they actually get the terms of that transaction, until they actually get what they need to follow so that they meet the provisions that's in their agreement that's obviously broken. So we're all relying on a third party. That's just like, I guess, the bottom line of it. We're all relying on third parties, third persons, and individuals to see that the inner workings within the internal workings are all working together. On the outside, we got to make sure within they do right. So that means we're relying on information. If they rely on information from the payment networks is going to be Visa, American Express, whoever they work with. They're relying on what they say about this document and the issuer's rights when it comes to it. The payment networks said the issuer has the rights and the obligation to transfer based on current sections or standard practices to give you this document that's going to be apparently on his face messed up. They said in Article 2, but they're speaking about it again here to allow in Article 5 to allow for them to have good faith to fix it. And that's what they start talking about under the section if you see a mistake on your statement, if there's error, if there's potential error. And that's when they begin to speak about, hey, if it's wrong in your letter, write me in your letter. Let's say something in your letter, talking to them, instructing them about what could be wrong according to just their standard practice. But there's things that are otherwise provided. There's things that's otherwise agreed. And the applicant use your document for those other ways, just as long as the issuer don't dishonor it, or for as long as the insurer get the actual presentation, but they can't even get it directly through them. They have to deal with a payment network. So Navy Federal not going to them, giving them anything. The payment networks is. So we need each other. Presenting the same document and just adding to it. That one page you get, they're gonna add something else to it. They're gonna add something else to it. All the way up until it gets to who it needs to be presented to. With all of the documents. See, they got an S at the end of documents. They start to talk about them. I didn't even see that here. They start to talk about them. And how it's failure if you gave notice without, these other documents. It might be fraud, forgery, like they mentioned before in the definitions. How y'all feel?
So that's why you kept saying business failure.
Yeah. Yep. And you're gonna see that in one of my messages that I sent. People don't think it means nothing. That business failure is the exact same business failure that's causing the penalty. People don't want to focus on that. They want to focus on fees. They want to focus on interest. They want to focus on shit that's just not dealing with the document. People don't want me to say it. What y'all want me to say? I can't really put a name on it. When I got it at the time, I got a document. I got an item. I got a payment. But I can't say that to them. So it's it. It to you, it to me, it to them could be a number, a variety of things based on the agreement that they are holding. It's just it. It needs all the terms and conditions to be met. It. Whatever it is, they'll see it. What they'll see, particularly on the face of that document, something is missing. If something is missing for it, it gives them the opportunity to have good faith with the merchant to correct it. They'll take corrective action. Or the individual who got the account, who know that it's appearing there and they know how to comply, like she kept telling Jared, you already got it. You can comply. It's up in the air. It's based on what you request. It's based on what you do. It's your actions that you take. But what I try to get everybody to understand is that action can be taken in a sense. Someone else will act like you on your behalf. Y'all with me?
Yes.
Who with you?
Okay. Issuers' rights and obligations, except as otherwise provided in section 5-09, the next section. So except in the next section, the issuer's rights and obligations, an issuer must, has to honor a presentation that, as determined by the standard practice referred in subsection E, appears on its face strictly to comply with the terms and conditions of the letter of credit. Is left blank. The amount is left blank there so that it can be referred to a practice by another person, someone who's actually going to honor it. The exact same issuer who, according to those standards practices, sent it to another person, apparently with the face left open to give you the opportunity, and then the opportunity to work with payment network processors in good faith. Except as otherwise provided in section 5-113, nonetheless otherwise agreed with the applicant, the person who's holding the document, an issuer shall dishonor a presentation that does not appear so to comply. So this is why you got it. They're telling you when you get it, it's a mistake, it's some potential error. They had to present it to you for that reason. They had to present it to you because it doesn't comply with the applicant's terms of being a letter of credit just yet. It's apparent on its face that this document has just been handled according to standard practices. What about custom practice? How y'all feel? Custom practice that complies with international transactions and trade. That's another condition that calls for another term And it's going to be apparent on his face of his documents. It's not there. It has not yet been determined according to the issuer's rights to determine the rates. How y'all feel? What's y'all thoughts?
I don't know what my thoughts are.
That's okay. That's okay. When you get your bill, it's just referred to as being a part of the standard practice. It's a part of being of a standard practice because whenever it appears that something isn't right or something isn't in compliance with the applicant, like maybe you signing up for credit or something like that, and credit hasn't yet been given, then they're going to give it to you. They're going to dishonor the thought of presenting it to another issuer or back to the issuer until you have the opportunity to agree otherwise, that this issuer should not only use it according to standard practices, but utilize that spot right there where the amount is left open apparently on his face to present the document in compliance with whatever rules that they have for using the document. How you feel?
That's where we say they need to get instructions.
Yeah. Instructions on how to complete the term. They may not know how, but guess what? They have family members who they can learn from, discover from. And that's what'll be provided unless it's otherwise agreed that it shouldn't be. But they clearly requesting that you say something and you make sure this document is in compliance. They gave it to you. They asking you to request that they take it further. Literally. It's required that they do before they actually take it further without you. So the issuer sent it to you first, even though that same issuer could have did something else. They sent it to you first. The same issuer will honor a presentment that's sent back to them too. An issuer has a reasonable time after presentation, but not beyond the end of the 7th business day of the issuer after the day of his receipt of the document. 7 days, 7 to 10 processing days. Reasonable time is 3 to prepare the documents. By the 7th to 10th day, you're gonna see something happening with those documents. They need to be in receipt of all of them. So everybody get reasonable 7 to 10 days to act. You can take the week off, or you can take 5 days off, or you can wait 3 days, and then you can act. Because from day to day after you get it, things change. Things are happening that's well beyond you bringing that document to an end. Reasonably. Presentation determines it. So an issuer has a reasonable time after presentation, but not beyond the end of the 7th day, business day. That's important. Seeing the word business there is important. If it's at your residence, then it's not at a business setting, and that's the first problem. Business day. You don't operate on business days. You operate every day until you expire. But an issuer has a reasonable time after presentation, but not beyond the end of the 7th business day of the issuer after the day of its receipt of the document to 1, honor it. 2, if the letter of credit provides for honor to be completed more than 7 days after presentation, to accept the draft or incur a deferred obligation, which is your payment. That payment should indeed be deferred. That payment being deferred is another obligation for another person to accept your draft and present it to another person completed. That's the terms of letter of credit that has not yet been met when you get your billing statement. Has not yet been met. Or to give notice to the presenter of the discrepancies in the presentation. What's wrong with it? What's missing from it? What's the discrepancies? What's otherwise? What's the exceptions? What's the differences? That's what's needed for a presentation. And up until a presenter used that notice or a presenter received notice that they're deferring payment so that that obligation and rights can be met to accept the draft and present it to another person within 7 to 10 days, it ain't gonna happen. So everybody in Houston, 7 to 10 day processing from them. Because they accepted the draft. Because they deferred my obligation and incurred it for financial purposes to present it. It has some discrepancies that they could see. They saw some failures, business failures, and those business failures was causing discrepancies in the presenter's notice. So they sent it to you, showing you, like, look, defer your obligations and all of your rights to this document so that somebody else can accept the draft. And at the 10 days of doing that, or at the 7 to 10 days of doing that, it'll be presented for credit. Letters of credit, because they're going to have more than one type of document that they're going to add to it. And if you're not going to sign each and every one of those documents like you did the first time when you was the applicant, you should reconsider trying to sign this one. Can you? You can. But I'm pretty sure that they could do it because it provides for honor by a business. Y'all got any questions? How y'all feel? Y'all don't get no questions about your document?
I mean, I have
About
plenty
your
of questions
notice?
on my documents. But no, as you're explaining it, it's starting to make a little bit more sense. Yeah, I get lost when the guys go between different people, but the action that needs to happen with that document is a little bit more easier for me to understand as far as what I expect for them to do as an individual, what I expect that person to do.
And what you expect to do. Look at the discrepancies. Look at the differences. Don't look at them. Don't look at the potential error. Don't look at none of that. You already know. They know it's there. They know it. That's why they said it. What is the discrepancies? What hasn't happened? What is the differences that could be applied to complete the document that has not happened yet? Presentation like that can only happen after reasonable time has been given from an issuer to another person. So once you get it, what's discrepancies is about it? They told you everything that should be met, but everything ain't met. Only one transition provision was met, but there is another. Except as otherwise provided in subsection D. An issuer is precluded from asserting as a basis for dishonor any discrepancy if timely notice is not given, or any discrepancy not stated in the notice if timely notice is given. So when your timely notice is given, there are some discrepancies of what's not stated. It's the amount. For that certain basis or on that basis, it calls for dishonor. So that means that whenever you get that notice, you need to quickly have that document immediately. So they say, used to be presented so that those discrepancies can be corrected. Because of failure. Failure to give the notice specified in subsection B or to mention fraud, forgery, or expiration in the notice, it does not preclude the issuer from asserting as a basis for dishonor any fraud or forgery, as described in section 5-109. That's the next section. That's the section that they was talking about here that was otherwise. Or expiration of the letter of credit before presentation. So before the presentation, there is an expiration date. The expiration date, and they have the opportunity during that time to reasonably get that document to you to stop unauthorized signatures, unauthorized use, any fraud, any misrepresentation, anything that may be wrong with it. They have the ability to give it to you due to business failures. May not have been their own, but a member failure or an issuer's failure. Really a debtor. I don't want to put it on the issuer. The debtor. How you feel?
Because the debtor is the issuer, right?
On paper, on the filing, on the UCC-1, they put their stuff in that position because they was directly doing business with you. All along, they're doing business with someone else, the issuer. Somebody who backing them with funds to come out and, deal with you without them directly being involved with fraud, forgery, or any expiration date when they know that they do things for the whole year. They get a whole year or up to 5 years to actually deal with these documents and even longer. But if they're not directly dealing with you, then that rule you don't have to know about. That's something that happens after. An issuer they must observe standard practices of financial institutions that regularly issues letters of credit. So the reason why you have that from a financial institution in the state is because the issuer, whoever your issuer may be, they have observed standard practices. Standard practices is using just financial institutions. That's regular. When you're using U.S. financial institutions, it's different. It's based on the determination of the issuer's observance of the standard practices. It is a matter of interpretation. How do you interpret it for the court? That's up to you. Each and every person, whenever a standard practice has been issued or you have observed a standard practice, from that point, you have the opportunity to interpret the matter in any way you see fit. The court, the person with the document, shall offer the parties a reasonable opportunity to present evidence of the standard practice. They presented to you evidence of a standard practice, prima facie evidence, standard work, standard APRs. They presented that to you. At that time, you have the opportunity to interpret why, make a determination, and use that regular size letter for another reason. With the U.S. financial institution, notice that they have an S at the end of institutions. It's just that all of your payments are used as financial instruments if it is regularly observed according to commercial standard practices. How y'all feel? What's your thoughts? So you decide. Financial institutions from what's regularly observed, or U.S. financial institutions from a determination from another person observing why the standard practices was even a matter in the first place. It's based on how you interpret it under Article 1. Why did you receive your notice? Is it for you to conduct another transaction? It should be. A type of determination is held by you and what you reasonably can offer to another once the opportunity presents itself. What's your thoughts? How y'all feeling? Practice. Standard state.
Right.
That's
When
what
we
you
get it, they're going along with standard practice, but we're trying to activate these customary practices. So
Yep.
they can be part.
Exactly. You have that opportunity for customary practices to be utilized whenever you make that determination because you actually have the document. You actually got the offer. The way you accept it is on the way that you consider accepting it. What did you consider? Did you consider factors of the CFPB like them? Or did you consider other choice of law and what's permitted and customary? Like, what did you determine? Why do you believe you got this statement? Why do you believe there's potential error? Maybe there hasn't been a determination of where it should go reasonably. Maybe they're just doing it by standard practice, and because I was considered to be an applicant, I got it.
Oh, damn. Okay. So I personally believe that I received this document because of standard practices. That's why it came to me directly. But I believe that it should have actually gone to whatever the payment address is on that statement. So that's what's in the agreement. I also feel that there's discrepancies in the document, with the price because there's either
Exactly, Jared. And that's stopping
So-
another person from being able to actually perform or utilize the document.
So customary
to
practices
examine
can
it.
be allowed. Okay.
Oh, no, I'm listening.
No, I was saying we get it, but because standard practices are being applied, so we need to observe it so that customary practices can be applied.
Yes, it will be applied according to standard practices. That means that, just like they told us previously, they will be examining it.
So just to make sure, standard is UCC and customary is federal. And
any other chain any other regulation that will go along with it, because it's adding additional terms and conditions. How y'all feel? It's based on performance or non-performance. That's what they about to get to in F. That's why I'm asking y'all that. I know I'm throwing a lot at y'all. Y'all gonna probably catch a lot after. But that's the reason why I'm asking, because in F, you see they got another list of 1, 2, and 3. Now they're about to be given responsibilities, talking about what people are responsible for and what they're not responsible for. The same thing that you affirm on the back of your statement. What they're describing here is different accounts that these banks is using. And that's the exact same information that is described on the back of your bill. Just in a different way for the issuer. Because they will be the one performing once they are advised to, or once they work or have inner workings, interim internal things happening.
Are there things that would prevent the intermediary bank, the person we're returning back to, in this case, Navy Federal, from getting it to Navy Federal Credit Union or to a payment network?
Yeah, the exact same way it comes. That's what's preventing them. The discrepancies in it, the discrepancies of it, what's missing from it. That's what's stopping it. That's what's causing the potential error. So whenever you contact somebody, you'll be contacting them literally in error, telling them these discrepancies, or you'll be contacting someone about potential error, allowing for them to examine and request if there is some discrepancy. Could it be used another way?
Could it be used another?
It just depends on who observed it, what they're observing it for. They're observing it with knowledge for the usage of particular trade other than standard practices, or are they staying basic? That's what they're about to talk about in F. So, F, an issuer. An issuer is not responsible for the performance or non-performance of the underlying contract, arrangement, or transaction. You are. The issuer is not responsible for an act or omission of others. You will become if you got it in your hand. Or the issuer is not responsible for observance or knowledge of the usage of a particular trade other than the standard practice referred to in the subsection E. That standard practice that's referred to in subsection E, you are responsible for knowing why you received that notice. And that particular transaction or particular usage or particular knowledge or what you should observe will automatically be on there. That information is not missing. It's already there. Now there is acts, an act that the issuer will become responsible for acting under, but not unless they have to observe performance of other opportunities, ones that are custom, ones that must be arranged. That means that me and you got to come together to transact, to keep our commitment and our promise with this payment processor network. If we continue to allow them to keep transferring funds and balancing in multiple ways. Fault. The issuer is not responsible for fault. Somebody else is responsible for fault. You gonna be responsible for filing your transaction. If as an individual, you get that transaction and you don't notice that the reason they gave it to you is so that you can see something is wrong, you're at fault. You can observe it. You can know about it. You don't have to have the knowledge. Somebody else will have the knowledge of the particular trade. But the issuer is not responsible for seeing that it's observed in trade until you actually make sure that whatever undertaking, underlying commitment, or promise to form a contract has actually been met. This is where they'll say you have this credit card agreement and a disclosure agreement, and that's your contract with us. How y'all feel?
This here is just saying like they're not responsible for our lack of knowledge. Us not putting them on notice.
Yep.
If we don't do that, then they'll just keep on with their regular standard practice.
Yeah, because in the agreement it says that what they're responsible for, what you're responsible for, they give you different acts. Those acts is not missing, that you can clearly see that that's what they'll act up under. It's just that they need certain money allowance to even do it. So non-performance ultimately turns into non-payment. G.
So for us to work with the seller to make sure all those provisions, everything's there, so that the issuer can then use that for a letter of credit.
Yes, exactly. They will be extending it. Has to.
Okay.
So extending, extensions is of credit, and different letters about that credit from different and each and every person who is supposed to sign what they need to sign. Our name already there. So for us, it's really done. The amount there, it helps to identify you so you could sign their signature. They said a signature could be there, anything else, but they said that the issuer could do it too. The issuer is just not responsible for doing it without you requesting that it's done. Because they operating based on and observing standard practices. Where is my chart?
I did notice in a lot of agreement and pretty much most bills that I get, they all have the Military Lending Act. Is that significant to all lenders, or is that just something like the federal government mandated they put on there? Or is that
Yeah,
kind of an act they're trying to activate?
So normally that one, the U.S. Patriot Act, it's a few other acts, but those are protection acts, and it's basically just acts for those who service. It don't matter what type of service it is. When you think about military, think about service. Not to disrespect anybody who actually serves in the military, but military is service, and that service can have an S at the end of it. How you feel? So services, acts that that particular person will service you under, and then they will be responsible for other acts like Military Lending Act protections, Service Lending Act protection. So anybody who they're servicing, they're able to be protected under this act. If they're able to act under this act, then that means that they will be responsible for this act, Fair Credit Billing Act. That means that they will use this letter to do it. And this is what you're gonna see on the back of your bill. Consider the notice and the claim of it. For family, for members, for different people within their organization. So that's why I say the acts are for them. They're just gonna act like you under those acts whenever they can or how they can. And they can do it in two different ways. But only if it's authorized by and through you for that sort of arrangement, that sort of transaction, that sort of, seeing it through, seeing the agreement through, contract. They said that here too.
For customary practices.
Exactly. That's a disclosure. That's something that got to be expressed. That's something that got to be said. And then that's something that'll be agreed upon. Other than that, the credit card agreement and the particular term that it's dealing with is through the state until you interpret something else. That's what I tell people. I might need to say Article 1 for a minute.
Kamai, I'm not even, honestly, this whole time, I just been going over Article 1, trying to get an overstanding of anything that I may have missed so that it all can come together,
Because you see they keep mentioning it. You see it keep going right back there.
Right.
You look at that Navy Federal agreement, that's what they're talking about immediately about your agreement with us. Immediately you agree that you're going to transact with me. You got law that is allowable, then you got law that is applicable, law that is permitted. Like, come on, we under an obligation to perform with each other. We got to create this contract.
Kamai, honestly, I think you could do a 10-week course on just Article 1.
No, for real, I could. I really could because of the aspects of it. I'm talking about Article 1 applies uniform. So each and every person that they talking about here, they going back to Article 1 too. So from each and every person hat and perspective, you can see how they'll transact. And that's really cool. Because everybody transact different. So, those issuers, the confirmer, the presenter, like all of them transact different when you use the document. So going back and forth after you get into, like right now, Article 5, we're talking about commercial and international trade transactions. You go back to Article 1 and see what each person doing in each set and each transaction in each way. You pretty much got it all the way around the board, commercial and international trade. And that's what you see a mix of here. Commercial and international trade.
Now, Kamai, I may have missed it. Now, does Article 1 talk about standard and customary practices as well?
They more so speak on customary practice. Standard is state, so they don't have to speak about that. We're under the state. We're looking at state law.
Right.
It's implied. Right. Express is customary. That's what has not yet quite happened or have been adopted.
Yeah, I think of 1-3031. I think.
Yeah, deal and trade. Performance. They're like, what's up? I'm gonna perform one way because it's referred to as standard practice, but it is another way that's according to customary practices within my business that I'm able to do. But I ain't got to do that until it's arranged for me to actually do it, or I confirm, or it's determined that that's what needs to be happening. That's what's being observed. It's based on another condition. So your terms determine your conditions. So certain conditions is going to disregard the other one, and shall, until something actually come about. This is why it's okay that you have nothing. You want to have nothing so that you can create and talk about something. And they'll use these codes. But they just talk about documents. That's all we talking about from Article 1, agreements and contracts. They want you to know that they want to use these agreements and contracts according to their policies. And for as long as they can use it according to their policies, then they're transacting an insurance every single time they make the claim. If an undertaking constituting a letter of credit under Section 5-102A10 contains non-documentary conditions, an issuer shall disregard the non-documentary conditions and treat them as if they were not stated. That's why you got it. They had to. They must. They shall. That document wasn't containing all of the conditions, let alone the terms of a letter of credit. So they had to treat it as if standard. They had to treat it standard. As if whatever they know could be stated actually ain't stated. They got to disregard it until that document contains that information. When it contains that information, then that's when they'll use it according to trade. Now they'll practice particular trade. Otherwise, they're just practicing standard form. An issuer that has dishonored a presentation shall return. You ain't returning. So if you're saying I want to return, then they pretty much don't know what you're talking about. They have no clue. No clue whatsoever. I'm pretty sure if you request something, they will return though. But an issuer that has dishonored a presentation shall return the documents or hold them at the disposal of and send advice to the effect to the presenter. The issuer gonna give all of the advice. The issuer gonna tell them what to do with the document so that they can return it. The issuer will give them special instructions to the presenter. You're not gonna be the presenter. They presented advice to you about what and ways that you can dispose of the document or how it could be used or how it may be used or why another person may be holding them and they're holding it because they can't do money orders, travel checks, cryptocurrency, digital. They're going to tell you all of that. There's some conditions that's placed that's limiting them for taking things a little bit further. So you need another term. So you can add another condition that will allow for them to use the documentary draft. Any questions? How y'all feel? That was a lot. Y'all like, but y'all thinking about it.
No, I'm definitely thinking about it, and the fact that the issue is that it also help us and or aid in the process, I should say. There,
Yes.